To be patented, you don't just have to be patentable subject matter. You need to be novel, you need to be non-obvious, and you need to be useful. A patent attorney can also tell you if your idea is patentable. Going to the patent office is expensive. It takes a long time. Patents are in the the thousands of dollars generally. There's a bunch of different types of patents. The two that we're going to talk about here, you can have a non-provisional or a utility patent. Those mean the same thing. Or you can have what's called a provisional patent.
Welcome and thank you for joining us for another Justia webinar. My name is Nina and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker today, Daniel Cole. For over a decade, Daniel Cole has guided independent inventors, startups, college professors, industry professionals, and established businesses through the complexities of intellectual property law. As a registered patent attorney with a specialized focus on chemical and biochemical companies, he evaluates patent and trademark eligibility, drafts IP applications, and advocates for clients in both protecting their rights and defending against unjust infringement claims. The webinar presentation that you're about to watch will be approximately 75 minutes, and Daniel will be taking questions from the audience at the end of the presentation, time permitting. So if you have a question that you'd like to submit at any time for us to answer towards the end, you can do so by clicking the Q&A button in the control panel at the bottom of your screen and sending them in there. Now, without further ado, here is Daniel to discuss basics of patent law, stop, think, call, knowing when to consult a patent attorney.
Okay, there we go. Now this is working the way it's supposed to. So to answer the question that Nina asked me, no, this is not my dog, or actually a real dog. It's a real dog, but it's not one owned by anybody at Chambliss. This is just a dog that Chambliss shows from a stock photo. But Chambliss is a minor law firm, a medium-sized law firm in Chattanooga, Tennessee. We try to be fiercely loyal. We are a full-service law school, full-service law firm. Boy, I need to calm down, don't I? We are a full-service law firm. So we have all of these business areas here that we go to. I am in the patent section. And as Nina was so useful to say, I do work mostly on biochemistry and chemical activities. I have done some engineering and have done some computer patents as well. So this is going to be extremely basic. So, if you're a patent attorney, I apologize for that. But this, I'm going to start with the basic necessities for a patent, to go through how you can tell whether you might have something that's patentable or not, talk about 101 issues, talk about what it means to be novel and obvious in a patent, using examples from things that are in the biochemical and chemical realm. So, several necessities for a patent. Some of these will seem fairly simple. They're really actually not, like most things in law. You first have to have kind of patentable subject matter. And that's become a major thing recently with cases like Myriad and Mayo. According to the Constitution, to be patentable, something has to be a machine, a process, a manufactured product, or a new state of matter. Be thinking about things that you might think that are not any one of those things. It also has to not be part of what are called the judicial exceptions. These are called judicial exceptions because they're not arguably not explicitly in the law. The court kind of said that they're there because they are the basic tools of science, and there are not things that people should be able to get a monopoly on. I've arguably where the court gets their constitutional authority to make that statement is outside the scope of this presentation. I am, and hotly debated. The judicial exceptions generally are products of nature and abstract ideas. I have a whole second presentation that I can give on those if there is interest. Just let Justia know. To be patented, you don't just have to be patentable subject matter. You need to be novel, you need to be non-obvious, and you need to be useful. Now, novel and non-obvious are very specific things that we're going to talk about that have very specific legal definitions. One of the fun things to do is when something is not patentable, but you still kind of have to tell your inventor that, hey, this is actually still novel and non-obvious, but not enough for a patent. Never a fun conversation. Useful is not as important as it used to be. It was generally done at first to give to allow the kind of government to say things like dances are not patentable or copyrightable because they are not useful. It's not now as important as it used to be, but we'll get to more on that later. So just want to give a brief discussion of some of the science behind the examples that I'm going to use. The first thing I'm going to talk about is I'm going to talk a lot about CRISPR as an example. If you're not a biochemical person, it's absolutely fine. I'm going to try and explain this in ways that even the non-biochemical people can understand what we're talking about. So, DNA is going to be the things inside your body that code proteins, kind of that code the chemical structure of all the proteins that make up the human body. For a long time, there were clusters of repeating DNA, and by that I mean the bases that make up DNA, adenine, cysteine, uracil, thymine, those sorts of things that were repeated. So DNA is a huge, big structure. Repeating amino acids, generally 3 of them that go, in a specific sequence. A repeating sequence is going to be like A, B, A, B, A, B, A, B, A, B, for over a specific length. It looked like junk DNA, kind of because it was generally often in between the things that we knew coded for proteins. It turns out these are pieces of bacteriophage DNA. Now, a bacteriophage is things that will attack bacteria. Okay, so they go into bacteria and destroy the bacteria. CRISPR is a particular protein that finds this DNA in a bacteriophage, snips that, removing the DNA from the bacteriophage, and then kills the bacteriophage. It's kind of assumed that it's in our DNA so that there's an example of it that the DNA can then use to find the DNA in the bacteria that it wants to kill. It's kind of a part of the immune system. It's useful because it can be used as a way to very specifically edit DNA. So the way CRISPR works in nature, you're going to have a virus that's going to come down in to give double-stranded DNA. The virus is going to split, but you're going to have from CRISPR, you're going to have the inactivation of the viral DNA. This is used then to create a novel spacer within our DNA so that the CRISPR can come in and then later you target that viral DNA when it sees the DNA again. Okay. Now, the other thing I'm going to talk about is what's loosely called directed evolution. Evolution's obviously how we became what we are from lower orders of organisms. It's useful because there are various things that can cause DNA to mutate in bacteria and animals. Good mutations can lead on generally into better survival. Bad mutations lead to things that don't work. You die out. In directed evolution, you're basically taking something and you're adding mutagens. And it's going to cause the DNA or the protein that's close to what you want that DNA or protein to do to, but then to mutate. So maybe it gets closer to what you want it to do. Say you have a protein that increases freshness in a tomato, and you're looking for something that you can insert into a potato that will increase freshness. You might take the tomato gene, add mutagens to it, do things so that the things after it mutates, what is closer to the activity you want survive, while the things that are farther away from the activity you want die out. This is generally done using something you have like a gene library, which is just a bunch of genes that you're trying to express. You express the gene library. You go through an activity assay where you're looking for the activity that you want. You isolate things that are close enough to whatever it is, the activity you're looking for. Things that are not close enough then die out. You isolate that gene. You then mutate that gene in various ways, and you put the results of that mutation back into a gene library. And then this is an iterative process until you get close enough to whatever it is you're looking for. Okay. So just keep that in mind as kind of basic science that I'm going to talk about as I go through. But back to why we're all here, back to patentable subject matter and patent law. So I told you to think about things that might not fall into one of the statutory categories. Most things do. Okay. It used to be that we kind of thought that meant everything under the sun was patentable, because everything under the sun would either be a machine, a process, a new type of matter, that sort of thing. Turns out that's not quite so true. There was a novel and non-obvious cryptographic signal that they were trying to basically, if you look at this case, they were not patenting the process to make the signal or to get the signal to be in the cryptographic format. They were doing that. That would have been a method that probably would have been patentable. They were trying to patent the signal itself, the energy after it had been encrypted, after it had been changed to be encrypted. And the court said, no, this is not matter. It's not a process, so it is therefore not patentable. End of case. And they entertainingly, in this case, they did this despite talking about that they were aware of E equals mc squared, that energy is the same thing as matter. They basically said it had nothing to do with their decision. So, think about this when you're looking at something, if you think it's going to be patentable or not. And if your patent attorney is not, might be time to get a new patent attorney. Again, the action is in the judicial exceptions. As I said before, most things are going to meet the patentable subject matter classification. So the product of nature is the one that is most interesting to me of these, because I'm in the biochemical space. Until recently, the purified natural products, things like drugs or vitamins, were patentable as new states of matter. One aspect of the Mayo case, it basically made these things unpatentable. Besides making just natural genes unpatentable. You may remember this was the BRCA case, where they had BRCA genes that were very important in assessing whether someone was susceptible to breast cancer. The company that discovered these genes tried to patent these genes. Big, huge uproar. And the Supreme Court said, you can't do this. These are, products of God, not products of human ingenuity, products of nature. So this is unpatentable. This seems to mean that if you have a drug or a vitamin that you newly discover that is in its natural state, that this is now not patentable. Somewhat in doubt. I don't think anybody's actually tried to patent something like that and taking it to a court. So stay a little bit tuned, but if what you have is a natural product, you're going to need to worry about 101 when you're trying to patent it. And your patent attorney should give you some explanation on how they're going to get around the product of nature exception. Abstract idea is generally does not mean what abstract idea means in general parlance. I talk about an idea being abstract. I mean, it's not specific. I mean, it's going to be we're going to do this and then this and maybe this. Whereas specific would be, I've got to do step A, I'm going to do step B, and then you do step C. Or you do step D if this and this are true. What abstract idea means in patent law is related to that, but it's also not very clear. It's kind of abstract what abstract idea means. It's more important in business methods and computer patents. One example of this is if you have an old idea and you're going to put it on the internet recently, if you have something that was done before and you say, use AI to do this better, that's generally going to be considered an abstract idea and not patentable. We'll talk about obviousness in more detail later. Arguably, when courts a lot of times use abstract idea to get around having to do an obviousness analysis, the thinking is that they do that because doing an obvious analysis is expensive and yeah, we think this is probably going to be obvious, so we're just going to say it's abstract. Not what they should be doing, but right now seems to be what courts are doing. So looking at this, let's look at CRISPR and kind of see how CRISPR would apply to those judicial exceptions and why, despite those judicial exceptions, it is still patentable. And I think there's still an interference going on deciding who invented it first. The actual claim from the first CRISPR patent is, and this is going to be, unless you're a biochemist, you're not going to understand this, so don't worry about that. But it's a non-integrating epichromosomal vector encoding at least one of a Cas gene, clustered regularly interspaced short palindromic repeats, which are CRISPRs, or a CRISPR guide RNA, one or more target sequences, and one or more condition-inducible promoters. So this could be found to have issues under 101. Remember, in bacteria, DNA uses the Cas gene, CRISPR's guides RNA, target sequences, and certainly promoters of some type. Promoters are going to be specific parts of RNA that say, come here, bind this, RNA or DNA, come here, bind this, and synthesize this piece of DNA or synthesize a protein responding to this sequence of DNA. Because remember, DNA is kind of like a blueprint for making proteins. It really depends on how you interpret epichromosomal. Okay. In bacteria, DNA use one chromosome, and the CRISPR is integrated into that chromosome. However, an epichromosomal is generally going to mean you have more than one chromosome. However, bacterial DNA is circular, vectors are circular, is taking out some of the circular bacterial DNA enough. So this claim also is not limited to a particular organism. It's doing this in bacteria, and you're doing this with bacteria which take up other plasmids which contain bacteria in nature. So you have a bacteria, it has a circular plasmid, it's going to exchange DNA with another bacteria. It does that by taking a plasmid up from that bacteria. That has two plasmids in there, even for a limited amount of time, does it now have epichromosomal DNA? Courts Patent Office have generally said no. That's why this is now in interference and probably going to be an okay claim. But these are the kind of things that you have to think about if you're thinking about 101 when you have a biochemical or a chemical claim. So claim for directed evolution. introducing this is actually one that I wrote, introducing a selection phage mid comprising a gene to be evolved into a flow of bacterial host cells through a lagoon, wherein the host cells comprise phage genes required to package the selection phage mid into infectious phage particles, wherein at least one gene required to package the selection phage mid is expressed in response to expression of the gene to be evolved in the host cell, and wherein the flow rate of the host cells through the lagoon permits the replication of the phage mid, but not of the host cells in the lagoon. The phage mid is going to be just like circular DNA that has the gene that you're carrying about in it. When you're getting a bacteria to make a particular protein, you're going to put a phage mid basically containing that DNA in the bacteria, and then different promoters that are going to cause the DNA to express the bacteria, to express that DNA. So then you're going to want to replicate and mutating the phage mid within the closed host cells, and you're going to isolate a phage mid with your mutated gene that then you want to include again and continue to evolve it in the flow of cells. Here is going to be likely not 101 problems. We didn't have 101 problems. We did this. First off, it's a method claim. And to include this, you're going to have all of the parts of the method. Okay. And, you here have a flow of bacterial host cells through a lagoon. Now you can think about, you would have host cells in like a natural lagoon moving through, but I don't know of many lagoons in nature that have a constant source of mutating things unless they're right next to a nuclear power plant, for example. But we defined lagoon in the specification to mean a particular thing. Patents are made up of a specification and then claims. Specification are a long written portion that is used to kind of to define what terms in the claim mean. So we defined away from a natural lagoon in nature. Then it would also have to permit replication of the phage mid and not the host cell. A natural lagoon would permit replication of both the phage mid and the host cell. So since neither of these things happen in nature, bacteria is not flowing through a lagoon as the patent defines it, and certainly not at a rate where the bacteria aren't able to reproduce. No 101 problems with this kind of claim. Okay. That's generally the kind of things you're going to run into when you're thinking about 101 in patent law. And, if you have a biological claim, ask your patent attorney, what are the 101 implications of this invention? If they can't answer you, good indication that maybe you should probably try and find a different patent attorney. So novel in patent law is closer than obviousness and other things to what we think about it meaning in real life. But it does have a very specific meaning. Novel, generally kind of just means new in normal parlance. In legal terms, it has to be very specific. You think about an invention, you generally can take an invention down into specific components. You can think of a claim or an invention as being something that has part A, has part B, has part C, and has part D. Novel means that if you're comparing two inventions, this to be novel, the second invention just has to have one thing that the other one does not. So your invention has A, B, and C, but there's prior art that is A, B, C, and D. The first one does not make the second one non-novel. Now, it's a little more complicated if you're going to go backwards. If you invented A, B, C, D, and A, B, C exists, probably not going to be novel. Because, all you're really doing is adding something to something that already exists. So 2 existing, A, B, C, D, can make one not novel, unless, there is some reason to think, and people have thought in the past, that by adding D, you would make the first invention, A, B, C, not work. It's generally called secondary considerations, which are kind of outside the scope of this to some extent. But just to say that that's not, A and B, A being true does not mean necessarily that B is true in this example. It doesn't flow both ways. Okay. All right. So let's talk about CRISPR again. If we took this claim and we broke this claim down into its component, you're going to have non-integrating episomal chromal vector, which is encoding a Cas gene, CRISPRs or CRISPR guide RNA, target sequences, and conditioning-inducing promoters. If there was a patent out there or any kind of prior art could be anything that's published, a patent, a book, a magazine, a TV show, an article, it would need to have all of these things for it to be non-novel. If a patent had an epichromosomal vector encoding a Cas gene or a non-integrating epichromosomal vector encoding a different gene, is still novel, because you're not going to have that non-integrating part of the first element. And in the second one, it's a different gene, and you are required to be the Cas gene. Okay? So novel, it has to be exactly what you're talking about in the claim. And I talk about claims a lot here because in patent law, the game is in the claim, right? Your claims are going to define what is covered. And if you're talking about whether something is novel or whether something is obvious, you're going to be looking at your claim and comparing it to what else is out there. Not just other people's claims. If you're looking at a patent, you're going to be looking at anything that they have published. So anything that's in their specification, anything that's in scientific articles, anything under the sun, even if it's a PhD thesis in a Russian library that only one person has ever read. If somebody can find it and bring it to the patent office, it can make your item unpatentable. If it makes your invention not novel or obvious. Okay, here we go. So this is in directed evolution. Again, I've got this down to the various components of that claim. You have host cells with Fagement expression genes. And when you break these down, you can break these down in various ways. You could have broken this down as one component is a host cell. The next component is Fagement expression genes. Generally is not going to make a huge amount of difference. Sometimes in litigation, you might want to break down things different ways, but for our purposes, that's not hugely important. But you've got host cells with Fagement expression genes, expression of at least one of these genes tied to expression of a gene to be involved, the lagoon in which the host cells flow in and out at the rate where the phage can replicate, but the host cells cannot, the replication and the mutation of the phage and the isolation of a gene to be evolved from the flow of cells. If you're doing this with something other than Fagement expression genes, or where the Fagement of the expression genes are not tied to expression of a gene to be evolved, you are now novel compared to this patent. Because you have to have everything in the claim to make a patent not novel. You may also hear people talking about that this anticipates. If somebody says this patent anticipates your invention, that means that it makes it non-novel. So it's anticipation and novelty are kind of two words they used for the same thing. All right. So let's talk about non-obviousness. Okay. This is where most patents have issues and where most patents are denied. It's fairly simple to go through most of what somebody is going to look at for the prior art. We have sophisticated computer programs now that can do that. It's pretty simple to look at something and say this is not or is novel. Okay. Obviousness is much more of an opinion. Obviousness is basically, does this thing combined with this other thing, make your invention such that somebody in the art with knowledge of the art would have made it. Okay. So, if you're going to call around obviousness, you need to have somebody that really understands the art that you're dealing with, because you're going to have to get into the weeds of whatever art you're dealing with, of the invention. You're going to really have to understand the science. This is why if you're doing a biology or chemical invention, you want somebody with a biology or chemical background. Generally, if you're doing a very complicated engineering invention, you're going to want somebody with an engineering background. If you're doing a computer invention, you're going to want somebody with a computer background. Okay. It's really going to require good argumentation. It's going to require close examination of the art the examiner is citing, and you're going to have to point out differences in the old and new art. So one of the things that can make this very hard, and one thing to look about and to think about if you do a prior art search, if you look and see what prior art is out there, if all of the components of your invention exist and all you're doing is combining those components, that's an especially hard obviousness case to get around. Okay, I like to call that the Swiss Army knife of obviousness, because the idea is, you think of a Swiss Army knife, it has all these various things, generally all of which existed before, a knife, a toenail clipper, scissors, all these kind of things, and it's just combining them into one thing. The reason this can be hard to get around is because of a case called KSR v. Telefax, and it goes down a list of various things the Supreme Court said were obvious. Obviousness used to be not as hard to get around. KSR and Telefax made a lot of things more obvious than they were before. So the various things here are that if you're combining prior art known elements according to known methods to achieve predictable results, you're making something that's obvious. If you're substituting one known element for another, again, to obtain predictable results, what you're doing is obvious. If you're using a known technique to improve similar devices and methods in the same way as this technique was used to improve the other method or device, what you're doing is obvious. If you're applying a known technique to a known device ready for improvement, which what exactly that means, unclear, to achieve predictable results, you are doing something that's obvious. If you're applying work known in one field of endeavor to another field and you're achieving predictable results, what you're doing is obvious. So these were generally the ones that were new in KSR v. Telefax. Before, the things that were only things that made something obvious, or if it was obvious to try, or there was a teaching or motivation in the prior art. And sometimes courts could get really specific on that. It had to be like, you may want to try this to be very, very specific, to have the teaching or motivation. As you can expect, in the prior art, it doesn't really often, people don't say, this might also work. So a lot of things were not obvious that under the KSR v. Telefax standard now are. You may have also picked up that a lot of these talk about the ending is achieve predictable results. One of the big ways to get around an obviousness rejection is to be able to prove that your results were not predictable. Now, you have to have very specific things to do that, okay? Especially if you're doing a biochemical or a chemical invention, but really in any, you're going to need to have examples in your patent. It's sometimes also useful not just to have examples of what you're doing, but examples of what other people did before. What this allows you to do is to say, hey, here is this prior art. Here are the results of this prior art. Here are what I am doing. Here are the results of mine. I have improved something, or what I have done has done something that is not predictable. Okay, and you can't say that unless you can show and often compare the results of what you are doing to the prior art. Then, and depending on how you might have to change your claims as you go through the prosecution process, because when you're doing prosecution, you send a patent off to the patent office. They look at it, generally say it's not patentable for some reason. It comes back to your attorney. Your attorney looks at this and says, okay, how can I argue that this is patentable? Do I need to change the claims? That's called a claim amendment. Now you're going to go in, you're going to change the claims to try and get around prior art. Or do I have something where I can say, I have results that were unexpected? And depending on how you're going to need to amend the claim, you may have to add something in that is very specific. And unless you can show that adding that very specific thing gives an unexpected result, you're not going to be able to use that argument. So, if in your method you change 2 or 3 things, might be useful to have some examples where you change just one of those things, where you change 2 of them, where you change all 3, where you change the second and not the first and the third. Because then, depending on how you need to change the claim as you go along, you're going to be able to allow yourself to have the most ability to argue different things, and that different results were unexpected. Okay, now this is very important in biochemistry. It's generally important in engineering as well, and becoming more so. But if you are writing a biochemical and a chemical patent and you don't have working examples, it's going to be a very hard road. It's possible, but it's going to be a very hard road. So that's non-obviousness. So in biology and chemistry, specifically, you're looking at you're comparing generally structures of compounds, but you're not really doing this in 3D space. This is going to leave something to be desired, as you might expect if you have a biology or a chemical background. A complex compound where you replace a methyl group with an ethyl group, that seems to be a small change when you're talking and looking at something on a piece of paper. But this could be a big change in 3D. Especially when you're talking about a big, huge protein, where if you change one side chain, you may drastically change the structure of the protein. Be able to prove that that is what happens when you change something, if you do that. All right. You can overcome non-obviousness by pointing out, as I said before, the unexpected properties of the new compound. Obviously this compound prior art doesn't cure cancer, yours does. That's an unexpected outcome. Unless the prior art maybe gives a suggestion that if you did this to this compound, it might now cure cancer. Now, some not as important now, because most of the time now, if you have a chemical structure, you can generally define what that chemical structure is. But there is a idea in patent law that a compound and its properties are inseparable. The properties equal the compound. So if you can't define what the structure of your chemical is, but it does this thing, you can maybe define it by what it does. This called generally a means plus function claim. When you're doing that, it's not the best way to do stuff, but it can be an option. You're leaving yourself open if there are 2 different compounds that do the same thing and you've only defined your compound by what it does. Maybe this other compound infringes, maybe it doesn't. Maybe they can claim this structure even if it does the same thing and they can still use it. So, however, if you have discovered a new use for an old compound, you do get a claim to that new use. The well-known example is aspirin for use in preventing heart attacks. Was not originally known for years when we were using aspirin. Was discovered. They were able to get a method patent for the use of aspirin to cure heart attacks. Now, how useful that patent was, how easy it was to support, to defend, all those kind of things, questionable. But they were able to get it as a patent. It's somewhat unclear, it's becoming clearer, how KSR and chemical sciences are actually going to interact. You know, if you have a chemical, and a chemical you can think about is made up of various parts. You know, maybe these parts in other chemicals are, or different chemicals even, are known to do certain things. This part of the chemical allows it to bind to this particular protein. This part of the chemical gives it this function. This part of the chemical gives it this function. Can you use KSR to say if, you know, all of those separate things are known in different chemicals, and all you're doing is taking these pieces known to react in a certain way and combining them to something that does all of those things? Is that obvious? Maybe, probably not, or at least there'll be more arguments for you to say not. Biology, chemistry, biochemistry are kind of considered imprecise sciences as opposed to engineering. You know, we could argue all day whether that's a good description of the science or not. You know, generally, if I'm going to want to express a protein, I'm going to do it a certain way. I'm going to know it's going to work. But since it's considered an imprecise science, you know, there's a little bit more of allowability for things that might be considered not obvious. We're in a different situation. They might be considered obvious, but just something to think about. So again, you know, when we're talking about CRISPR, you have plasmids, you have an isolated plasmid, and this is the prior art. The plasmid was cleaved with a restriction enzyme. You had what are made sticky ends. You spliced generally with the same cutting tool, the human chromosome, the same restriction enzyme. You clipped out the enzyme that you're looking for because the sticky ends lined up, because you used the same restriction enzyme. You could insert the gene that you're looking for into the plasmid and get the recombinant DNA. And you could then have that bacterium with the recombinant DNA and express the DNA you're looking for. If you remember, then CRISPR, you have the virus. The virus comes in, creates these double-stranded DNA. It's inactivated because the DNA combined with the Cas3. Because the Cas has the DNA in it from the human genome, it knows to cut there and goes in and cuts the viral DNA, or it uses that DNA that it cut and creates a novel spacer and puts it in. So this is, you had to come look at these and say, okay, is this like the earlier process? You know, how does this compare to this? Does this make this obvious? Now, generally people have said no, but that's the kind of the thing you have to look about and you have to think about. You know, this is cutting DNA with a restriction enzyme, happens to be a restriction enzyme that's from a virus that's going into, you know, the virus bacteriophage is going to go in and kill bacteria. You know, and it is using this Cas compound to do it. But was it obvious? Well, no, that Cas compound was not known. If the Cas compound had been known beforehand, and maybe it is known to do other things, maybe this becomes more obvious. All right. So I'm going to talk a little bit about usefulness. This is, you know, easy to get past. This is basically to allow the USPTO to get an easy way to get out of claims for things like perpetual motions machines or inventions with a high unlikelihood of working. You know, you tell the USPTO you've invented a time machine, you are probably going to have to come up with some very specific things to prove what you have done. Okay. Now, as I said before, this was used largely in copyright law in the past to keep things like dancing or games of chance from being copyrightable or patentable. That has since gone away. The argument was, well, these things are not useful to society, so they are not patentable. Generally useful, you have to, for now, in current times, usefulness just means you have to prove that your invention does something. That cannot be it just sits on your desk and holds paper in place. Okay, it has to be more than a paperweight. So yeah, as I said, mentioned a couple times in the past, this was used to deny patents on things that the court found not useful, based on moral concerns, things like gambling machines, dances. But this has been discredited through the courts, thankfully, at least in my opinion. I don't gamble, but somebody comes up with a better gambling machine. A lot of people do. A lot of people enjoy it. Should be able to be patented. And I certainly don't see any reason that dances should not be copyrightable. Uh, take some money away from Fortnite if you copyright your dance and they use it, which to me is a good thing. All right. So I'm going to talk a little bit about the various things that patent attorneys do, go through again, because I have some extra time here, kind of the basics of the way of things that happen at the patent office and how that would go, how things might go when you talk to your patent attorney, the length of time that things take. So if you run into this, you know what to expect. So a patent lawyer can do various things for you. A patent lawyer can tell you if what you are doing is covered by a previous patent. Okay. Claims are very specific, but they can be broad. A patent lawyer is going to try and get as much coverage as possible for whatever it is that you are trying to invent or trying to patent. Okay, this can be very difficult without the knowledge of law to say what a patent actually covers. The claims that I mentioned in here, these were actual patent claims. And as you can see, it was English, but maybe not really. Okay. I'm a patent lawyer. I look at advanced claims for like a car engine. It's going to be somewhat difficult sometimes for me to parse those because I don't understand the science necessarily. Not if you want to know what a patent means and what it covers, you are generally going to have to talk to a patent lawyer. This is also true, as I mentioned before, because patents have kind of a long section before the claims. And yes, the claims define what a patent covers, but what's called the specification, which is generally going to have figures and a detailed description of the invention and a description of the figures, sometimes a summary and an abstract. These are kind of going to define what the claims mean. A lot of times patent lawyers can be their own lexicographers. What that means is they can define something to mean what they want it to mean. Okay. A lot of times in biochemistry, you'll say something has a range and the value of this can be between 3 and 4. You look up the term between, probably not going to mean that it includes the ends, that you're going to include 3 and 4. 3 and 4 are not between 3 and 4. They're on the ends. A lot of times what you'll see is people in patents will say, if I use the word between, or if I say from A to B, A and B are included in that range. And that's an example of an attorney being their own lexicographer. We will define things except like A to mean one thing, but also one or many things. Because this has come up in court cases and has become important. If you want to define a protein differently for some reason, then, the potential normal definition in science, you can do that. But those things are not going to be in the claims. They're going to be buried in the specification. So reading the specification in light of the claims in light of the specification can become very important. A patent attorney can also tell you if your idea is patentable. Going to the patent office is expensive. It takes a long time. Patents are in the the thousands of dollars generally, especially for a biochemical or a chemical patent, and they take years to do. So why not find out first if what you have is going to be patentable and how difficult it is going to be to get a patent from the patent office on it. Generally, the procedure for a patentability analysis, you're going to give kind of the same information that you would give if you were telling your patent attorney to write a patent. They're going to go through the prior art, they or someone else. They're generally some very sophisticated firms that do patentability searches where they will find a selection of things, sometimes 20 to 30, sometimes 10, that they will then send to the patent attorney. The patent attorney looks through these, compares them to your invention, thinks about, okay, based on what I know about the prior art, based on what I know about patent law, is this novel, is this non-obvious, based on what the prior art says, what exists in the prior art. Then they will give you an opinion where they talk about what, if, and how your invention might be patentable. A good one will tell you if it is not. Not everyone is a good one. Generally, they should also tell you how difficult this thing is going to be to patent. Is this going to take a lot of office actions and a lot of time? Or is this going to be novel and non-obvious enough that we may only have to do one or two? So, generally, when you write a patent, there's a bunch of different types of patents. The two that we're going to talk about here, you can have a non-provisional or a utility patent. Those mean the same thing. Or you can have what's called a provisional patent. Now, all the times when I've talked about prior art, that becomes very important when you file the patent. It's kind of just like with real estate. It's a rush to the patent office now, just like it'd be a rush to the courthouse for a deed for property. When you file your patent, that cuts off when the patent office can look at prior art. If you file your patent on January 1st, 2026, anything that's published after January 1st, 2026 is not prior art. This is why sometimes people will try to file their patent as early as possible. One way to do this is with a provisional patent. A provisional patent kind of stops the clock on when you're going to have looking at prior art, but it's not really ever examined. Nobody looks at it and decides whether it's patentable or not. Now, there's a whole lot of other things I didn't talk about. I mean, when you're writing a patent, you have to enable the patent. You have to have a written description that covers everything that you're trying to claim, more advanced than what we wanted to talk about here. But if you're doing a provisional patent, because of things like that, you want to make it look as much like your non-provisional patent as you can. Okay? You can get away with some changes in your later patent, in your utility patent or your non-provisional patent. But you want your provisional patent to be as good as possible, so that because if it's not, it goes away, and all these things that were not prior art because of your earlier filing date now become prior art. When you have a provisional patent, you have a year from the date of your filing of your provisional patent that you can file a utility patent. You don't do anything. So again, if you file the provisional patent on January 1st, 2026, you would need to file a utility patent by January 1st, 2027. If you did not file it in that time period, now you lose the provisional, it goes away. When you file your utility patent, you end up having the filing date of when your utility patent's filed. If you file it within that year, like before, everything is going to be before that date is only where you have prior art. Generally, it's going to take 6 months to a year to longer after you file a non-provisional for the U.S. Patent Office to get back to you and say whether something is what you have is patentable or not. They're going to give you that opinion in what's called an office action. Generally, an office action is going to say something is not patentable because it's novel or it's not obvious, or something else is wrong. You didn't include enough information to make your claims enabled, or your written description is bad in some way. Your patent attorney is then going to have 3 months without paying extra fees. You can go up to 6 months if you pay more fees to respond to the patent office, either by changing the claims or argument in some form that the patent examiner is wrong. Then you're going to have another 6 months to a year where the patent office is going to come back then and say, in what's called a final office action, whether they agree with you, you're now patentable, you're fine, or they don't. Final office action, but that's generally a misnomer. You can, by doing what's called a request for continued examination, go further and you go back to having another final office action or a non-final office action. Of course, when you do that, you're going to have to pay the patent office more money. Now, there are fees. You have fees for filing a provisional, fees for filing a non-provisional. They differ depending on the size of your entity. Larger entities are going to pay more. This is the idea being that we want to encourage even small entities or people working in their garage that have good ideas to patent them. But every time you do an RCE, and you can keep going as long as you want to, file as many RCEs as you want to. If you do that, you're going to have to keep paying money to the patent office. So that's why when I say patenting can get incredibly expensive, because every time you're going to have to keep paying your attorney, every time your attorney works on an office action, every time they work on an RCE, every time they work on a response, anytime they do anything, anytime they talk to you. So telling you whether your idea is patentable beforehand, generally a good idea because of that. Now, if you get far enough, that you are saying, okay, I don't think I'm getting anywhere with this anymore, you can appeal. You can appeal to the Patent Trial and Appeal Board, and they'll decide whether your thing is patentable or not. This is basically a tiny court case. It's an administrative court case. So incredibly expensive, can be an incredibly long, drawn-out process. Let's see. If you can then take things to the Federal Circuit if you want to, and the Supreme Court. These are how we got the patent cases that I talked about. If you were going to go even farther, that, of course, again, is going to increase more of your cost and more of the time involved. The term for a patent is 20 years from your initial filing date. So depending on how long you drag the process out, it could take you 20 years to get a patent. Your patent now becomes worthless. So always, I think it is a good idea to do some sort of patentability analysis and decide, is this idea patentable beforehand? So that you have an idea of, is this thing going to be worth the time and the money that it's going to take for me to try and get a patent on it? It's also a good idea for that reason to talk to your patent attorney as soon as possible. Okay, if you have an idea that you think is new and you want to protect it, it's time to talk to a patent attorney. If someone has told you that you are infringing someone else's patent, or if you think you are doing something that might infringe someone else's patent, it is time to talk to a patent attorney. Again, because like I talked about and like I've shown, claims are very complicated. And especially in the biochemical and chemical arts, things could be defined strangely in the specification. You may think you're infringing someone's patent. you may not really be. Patent attorney can tell you whether you are or not. Patent attorney can also tell you here is exactly what their patent covers. Maybe there's a way you can work around this patent. Maybe there is a way that you can still do what you want to do, but in a different way where you don't infringe this patent. You can also do what's called kind of a field analysis, where if you are going to start doing something, a patent attorney can look at the patents that are out there and tell you if what you are doing is going to be infringible or not. Okay, if what you're going to do is going to infringe someone else's patent or whether it isn't. Generally, also, it's a good idea to talk to a patent attorney if you have an idea and you want to talk to others about your idea, but you want to prevent them from disclosing it. Even if you think your idea, or even if your patent attorney tells you your idea is not patentable, you can still treat it as what's called a trade secret. Now, this means if you're treating it as a trade secret, you're going to have to do very specific things to protect it. You're going to need to get NDAs. You're going to need to make sure people don't have access to it who aren't supposed to have access to it. Patent attorney can talk to you and explain to you how to do that. Also a great idea, if you're going to disclose your idea, talk to your patent attorney, get some sort of patenting down, do a provisional patent before you disclose it. In America, you do have kind of a year grace period where you can still patent something after you disclose it. So if you disclose on January 1st, 2026, you can have up until January 1st, 2027 to patent it, but you lose any rights in Europe, you lose any rights in China, you lose any rights in most of the rest of the world, except for very specific circumstances. So if you are going to disclose a new idea to anyone, you should probably talk to a patent attorney first. Okay. So this is me before I decided to cut my hair off. I am licensed in North Carolina. I'm currently working in Tennessee. I'm working on getting my license transferred to Tennessee. That is what that practice pending admission there means. I've got my work phone and my email address up there. But I am happy to take questions at this time, and don't feel free to ask things. I taught community college for a long time before I started doing this, so I like involved audiences. I like questions.
Thank you so much, Daniel, for that wonderful presentation. So as he mentioned, we are now going to move into Q&A. As I mentioned at the top of the presentation, to go ahead and submit your question, you can click the Q&A button in the control panel at the bottom of your screen and send it in there. We already have a few, so I'll go ahead and read those out for you, Daniel. Our first question is from an anonymous attendee. They ask, since we're discussing different engineering needs depending on the application type for the patent, aren't all attorneys registered with the USPTO for patent issues supposed to have engineering degrees? Is that the case?
You don't have to have an engineering degree. You have to have a science degree in some form. So, and, a patent attorney that is barred with the patent office can communicate with the patent office on any type of technology. As I've mentioned, I've worked on computer technologies. I have worked on engineering technologies. I mostly work on chemical and biochemical technologies. But you have to have a science degree. If what you're doing is a computer invention, you probably want somebody that has a computer degree. You don't have to have that. To be barred at the patent office, you have to have a science degree in some form, or you have to have a certain number of hours in science courses. And then you can sit for what's called a patent bar. And if you have a law degree, to become a patent attorney. If you don't, become a patent agent. And either way, you can communicate with the patent office. So you have to have a science degree, not necessarily an engineering degree.
Awesome. Thank you for that clarification, Daniel. Our next question comes from Sandy. They ask, I've read that pharmaceutical companies will often make minor changes in dosage to extend their patent. Do they have to show that the new dosage has improved results? What have you heard about that?
Right. That's called evergreening. And you hear a lot of talk about that and how terrible it is and all those kind of things. Sometimes it is. Sometimes it is not. Generally, anytime you make a new patent, it is going to have to be novel and non-obvious based on anything that is out there before. There are some things where you can make a continuation that, would have a prior date and be related to an earlier patent. And this is sometimes what some companies will do, where they change something minor, make a continuation. Um, Often, if you do that, you still kind of have to prove, especially if what you're doing is a continuation in part, that the new things are novel and non-obvious over the prior art, over any, and that includes your prior art, your earlier patent. Now, you don't have to show that something works better. Okay, you can get a patent on something that works not as well, as long as the method of doing it is novel and non-obvious. Having a patent does not mean what you're doing is going to make you any money. It's totally unrelated. It just means that what you have is new and non-obvious. Doesn't mean anybody's going to want to buy it. Doesn't necessarily mean it works better. In the medical space, as expensive as patents are, as expensive as new medicines are, unless they think it works better, they're probably not going to spend the time or the money to try to patent it. But to specifically answer your question, no, they don't have to prove if it is that it works better. They likely have to prove that it is novel and non-obvious over their earlier patent. So if they're just changing dosage requirements, unless the dosage requirements, this dosage makes you have less of a certain side effect, which, to find that out, they had to go out and do research and see and do all these things. Unless it's something like that, probably not going to get a new patent on it.
Thank you, Daniel. Our next question is, in the context of biochemical inventions like CRISPR or directed evolution, what are some practical ways to distinguish between a product of nature and something that is truly patent eligible?
Okay. So I have a whole presentation on this. Generally, you're going to want to show differences. I almost want to bring that presentation up. I'm not sure if I could find it.
Yeah, go ahead. And if you have an example you'd like to show that'll be helpful for
Yeah,
illustration, sure. Yeah.
I don't have that one in. You're going to need to show that uh, it is different. What you are making is different from the prior art in some form. All right, let's open this. Um, you know, the 101 analysis is incredibly complicated. This is an example that is of the 101 analysis in general. Let me get to slideshow on this one from beginning. I like to call this one strengthening your walls concrete, because you're generally not, I can give you advice on how to make it less likely that you're going to get a 101, not get around 101, but I'm not going to be able to tell you how exactly you're going to get around it. So, this is the way they decide if something is patentable or not. This is from the practical application added in the 2019 by the Patent Office. You look at, is the claim directed to a law of nature or natural phenomenon? If it is, then you have to think about, is it integrated into a practical application? A really good way of doing this is doing what's called a method of treatment claim. You find a new drug or a new compound. You can't just claim that compound. Okay, you can't just say, I have this new structure. I am claiming it, period, any use. Or you kind of could do that. Most people really didn't. But, you find a new compound, you're going to say, okay, I am claiming this compound in the use of treating this disease. You are now surviving 101 because you're now going farther than what is in nature. Now, you may run into problems with novelty and obviousness if some tribe somewhere in Africa is using this leaf or whatever, if it's a natural product, to cure that disease. Okay. But that's one thing. And generally, a lot of things that you want to do. So, there's a lot of things about what integrated into a practical application means, examples of things that are not. You can also want to find significantly more. If you can say that what you're doing is significantly more than um, the product of nature, then you're going to be able to get around and do what you're doing. Okay. But as I say, that's a whole other presentation. But yes, there are some practical applications of that where you can say there are ways to do it.
Awesome. Thank you, Daniel. And thank you for sharing that example. Really helpful. Our next question is, when discussing novelty with clients, what are the most common misconceptions that non-specialists have about prior art searches?
Okay, so specifically about prior art searches, kind of generally I will get people that will say, well, I haven't seen this before, on the market. May not be on the market, but if people know how to do it, even if somebody's not selling it, that's still novel, not novel. Excuse me. And, explicitly, again, novelty is very specific. So even if you change one tiny little thing, arguably it's not novel. Um, but even if what you're doing is you're connecting something in a different way, arguably that's not novel. But I have seen some scientists or some examiners say you're just changing a bolt. This is not novel. You're using um, a screw rather than a nail. And sometimes a client will think, okay, I'm doing this. This gets me around novelty. What is called an equivalent, you're doing an equivalent. So that's not going to be novel. I've seen some clients talk about that. Generally, though, it mostly is I haven't seen anybody selling this. It's not on the market. I should therefore be able to get a patent for it, which of course gets all the way away from any kind of discussion of obviousness, which I say is the much harder thing to get around. Um, Generally just for novelty. Also, it's you have to have every element. So if somebody has a patent, I was talking to somebody yesterday, they think their patent's infringed because somebody is doing the general idea of what it is that they are doing. If what you have is a very specific claim, and claims can get, 20 lines, then they have to have every single thing to be infringing your patent. Now, infringement is different than novelty. It's different in obviousness. It's a slightly different way of looking at things. Generally, the idea is that um, if it would anticipate if it was before, it infringes if it's later. So if what you're doing is, because you have to have every element based on novelty, and if you want to infringe, you have to be doing everything that is in the claim. So I've also seen that.
Thank you for that insight. Our next question is, how should lawyers advise clients who have or want to disclose their inventions publicly through presentations, publications, etc., before filing a patent application?
Don't do it. Um, and I would tell them that, you're going to lose your rights to patenting in a bunch of different parts of the world. Now, there are ways you can, do it. You can say, I'm going to disclose it to these people, but I'm going to disclose it under a non-disclosure agreement. Then, okay, that is not a public disclosure. But if you're publishing something and it's available to everybody, even if you're publishing something and it's kind of only sent to certain people, I would not do that. Um, but if they're existing, make sure they get NDAs. Tell them you're probably going to lose your right to patent in Europe. Make sure you patent in the US within a year of the disclosure. And think about maybe filing a provisional patent, even if it's just their presentation, the day before their presentation. You know, I have done that. It's not the best. You may run into issues later, but you at least have something. And somebody's going to have to sue you because the patent office is really not going to look. They have not a lot of time to go through these very complicated patents and do these searches. So somebody is going to have to sue you, and they're going to have to find prior art that is in between the time of the provisional and when you file your non-provisional. And they're going to have to say, okay, now there's this issue. This prior art makes this not novel or obvious, and then they're going to have to find some way to get the provisional to disappear. So, and whether they're going to do that or not and spend the time or the money, you know, it's all about doing the best you can in that situation.
Daniel. Our next question is, in multidisciplinary practices, what are effective ways to collaborate with patent counsel specifically when you're in the early stages of product development?
Okay. So I'm mean a multidisciplinary practice. I guess you mean a multidisciplinary law practice. If you don't, please let me know. But in a multidisciplinary law practice, if you're like a single lawyer and you want to talk to a patent lawyer, give the patent lawyer as much information as you can. Okay. Do not think you're going to be wasting the patent lawyer's time, that you're going to be overloading them. You know, they're going to be able to look at stuff pretty quickly and say, I need this, I don't need this. This is much better than finding out something later that you did, if you should have told them. Especially if you have anything that's kind of that you think might be prior art. The patent attorneys, any attorney involved, and the inventor have a duty to tell the patent office about any prior art that might be useful or most related, is the word they use, to the invention. So give the patent attorney as much information as you can. Expect that you're going to have to go back and forth. The patent attorney, if they're good, is going to write claims, maybe even send you the claims to show your client before they write the rest of the patent. You know, I have to go back several times to my patent attorney or to the patent attorney, no, that would be me, to the other attorney, to the client, and say, here is the draft, does this cover what you want it to cover? Are the things I'm saying here right? Get good at using track changes in Word, in reading comments, because a patent attorney is going to say, we need more information here, we need more information here. You're going to probably need figures, so expect to have figures and have specific people who draft those figures. A lot of times when I've taken things from, I don't try to cut the other attorney out, but it's easier if I can talk directly to the client. If you're early in the process, like very early, you may want to look at doing a patentability analysis. You may want to do looking at the field analysis that I talked about, kind of to see what is out there. Where can I go? Where can I do my research to make what I'm doing might be the most patentable? There's a lot of patents in this. Maybe I don't want to research that. There's less doing this. Maybe I want to research this. Communicate the business objectives. Okay, this is probably assuming it's probably a business attorney asking this question. When you're writing a patent, the point is that you're going to have something that covers what you're doing and prevents other people from what you're doing. So, if your business objective is significantly narrower than what your patent attorney is trying to cover, tell your patent attorney that. They may still want to try to start with a larger one, but it'll make writing office actions easier down the road. And then lastly, I guess expect that it's going to be a long relationship because patenting takes a long time, years.
Awesome. Well, Daniel, thank you so much for taking our audience questions. And thank you to everyone who asked questions. We're out of time for today, but we really appreciate your participation.
Do feel free to contact me through email with further questions if we didn't get to you. And thank you for being a good audience.
Thank you so much, Daniel. We want to thank you all so much for being here with us for another Justia webinar. As I mentioned earlier, don't forget to take advantage of our powerful free legal resource available to Justia Connect members, our Justia Daily Opinion Summaries. You can get next day email alerts with those concise summaries and the latest court opinions for the jurisdictions and practice areas that matter most to you. And we also have our weekly patent updates as well. So whether you're tracking those key patent decisions or staying updated on other legal trends, you can sign up at newsletters.justia.com and never miss a key legal development. Thank you all so much for your time and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.